been nowhere. All the laws that the judge cited, there have been nowhere where after the jurors have been disbanded, I'm not saying where the verdict comes back and they are not disbanded, but where the jurors have come with a verdict and they have been disbanded, meaning the court has no jurisdiction on you, and the term of closed court has ended. That judge has no legal authority to call that jury back to question them on allegations of how they voted and why they voted the way they voted. It had never happened in our law, in our system. I challenge any lawyer or any legal practitioner to show that. That's one. Two, the law that we are talking about, the issue that have just unfolded today, this is the first time it happened in our jurisdiction. How? The first time in our country where a verdict have been returned, the juror have been disbanded and they are going into their communities. And then for the judge to hear an investigation, a complaint after the court have been disbanded and say that he has jurisdiction to return the verdict, to overturn the verdict, they are not happy. The only country that we have copied from that it has happened, that has spoken on that kind of issue, is the American jurisprudence. The American, our petition is that the American jurisprudence says that if the jury have been disbanded, any attempt to call them back, listen to it, there is a difference between jury returning a verdict that they are not disbanded, they still under the jurisdiction of the court, and the jury returning a verdict where they have been disbanded, like the Samuel Tweah case. The U.S. Supreme Court that we copied from under the doctrine of stare decisis says any attempt to do that, to call the juror back from the community to the court to question them about allegations of jury temper or misunderstanding or what happened, how they voted, they say it is unconstitutional and legally dangerous. That is why the U.S. Supreme Court.
My name is Christopher Bestman and I report for LNTV. At what position do you believe that this court has reached this particular decision?
At what?
I mean, at what position do you believe the court has reached to such decision in this case?
Well, I don't know, because I have taken the issue before the Supreme Court, and what we agreed on when we came back, before we come back, when I filed the first prohibition, it was the issue of jurisdiction. Jurisdiction is not something that you do it by the consent of the parties. Oh, let's agree that we must have jurisdiction, you can do this. No. Jurisdiction is what the law says. When I say jurisdiction, it means from February this year, where the court was open, and the court ended at the end of February going to March, and then we extended up to what? June and July. You cannot have a hearing about a decision as a trial judge for what you did in February, because what the court has authority to open 4 times a year. When that one of those 4 times is up, you can't go back. It is by law. It is not the situation of people agreeing. It is by law.
You believe that you were part of the investigation council.
Because there is the same application you filed before the justice in Chile. The court lacked jurisdictions to hear this matter because they have already disbanded the juror, the verdicts have already been made. The same court presiding justice in Chimon sent you back and said that the court had jurisdiction to do this.
Maybe many of you did not follow. When we filed a petition, the justice in Chimon did not decline to issue the writ. The issues we raised, especially when the judge decided to have the investigation in the absence of the parties that you saw in there, were due process issues. So when we went to the justice said that is a cardinal issue. So in order for us to have a situation, since the judge said he wants to investigate, let us use guys to sign a stipulation on the agreement of due process to see that the judge gives the opportunity to everybody to be present and to answer questions, to produce evidence against themselves, against whoever that is against them, and to prove their case or to provide evidence. That was what we agreed on. So we signed what we call a stipulation. A stipulation is a joint agreement by the 2 lawyers on both sides, agreeing on the terms and the conduct of the investigation, even though in that we still maintain that the court did not have jurisdiction. That is why even when we come, the justice said when we come, we should register it as a matter of record. We raise it again as a matter of record. That is the law. That is the practice. That is the procedure. So we raise it as a matter of record that you do not have jurisdiction. He said it's granted. It is provided for by the law. So this investigation is not an end in itself. Whoever is not satisfied, we will take it to the level of the Supreme Court. Our concern here is not about jurors. Our concern here is the verdict that was returned. Samuel Tweah is a free man. To destroy that verdict is a Pandora box opening for the government. Why? Let me tell you the danger of what happened here today. In the future, if any other government, I'm not saying the government, but any other government has a case and interest in a case, and then they want a particular defendant to be guilty, and that defendant is not guilty, they can look for one or two persons among the juror or any other person to file a complaint of this nature, of juror misconduct and juror tampering, and they will conduct the investigation and revise that verdict. That is the clever attempt to undermine the clause in the Constitution we call the principle of double jeopardy. This is the danger. Now, it is not something short-sighted people will not understand about what is happening now. But what is happening now is dangerous for tomorrow. That tomorrow another government looking for anybody in this government to go after them to have them prosecuted, and they fail to prosecute them and the jury returns a verdict. They can do the same kangaroo thing and then manufacture complainants as affiants in the same case and allow them to come and file something, and at the end of the day the judge can say, okay, that jury temporary, even though I am not in term. This case started February, it ended March. The judge is hearing a case in February, in August.
Do you think those that complain were paid? Those that complain, the three jurors that complain, do you think they were paid to do so?
The three jurors? Of course they were paid. They were under control. You guys did not take part in the investigation.
You did,
the three jurors. First of all, the writing of the three jurors, it was a lawyer that wrote the writing. Okay. The lawyers that were representing the three jurors were the same lawyers sharing the same desk with the prosecution. Allegations in that particular investigation show that the Solicitor General is a boyfriend to the head of the jury, one of the jurors who complained.
The judge said it couldn't be proven.
Listen now.
The judge said we're not proving.
Listen, I didn't say the judge. Six of the jurors said, all of the time they were in there, the poor lady used to tell them that the man is her boyfriend and she loves the way the man can dress. So they decided calling him in their testimony, because I sat in the case from the beginning to the end, that they call the Solicitor General as Papa. They used to call him our Pa. And then they call the poor lady our ma. Those were things that were in the same. For the judge to say that what due process that he gave to say that indeed. So the whole thing is, what the judge is doing there is a ruling. It left with any of the parties to take advantage of the statute and the law controlling. You have another question?
How prepared?
What are you telling your client when he succumb to the court, or like he said on spoon, he will not succumb to the court at all?
Well, that one we're discussing.
Are you prepared?
So what does this mean for your client? You know, this jury.
It's not my client. What happened today is for the country. You didn't understand the argument I gave you? What happened here is for the country. Don't mind, because Ada Johnson representing Samuel Tweah, some people want to vilify him. No. Ada Johnson can represent another person. Even in the drugs case now, there are people that came to say I'm representing. So when I represent them, well. Now let me tell you something. I don't know what the problem some of you have in this country about Ada Johnson. And this is something I took off. If I was going to represent any of the guys in the drug case, tell them that some of you crossing me on the Facebook. All the law representing people, nobody disrespecting them. Why do I live? That's my profession. I'm not a partisan. I'm a lawyer. I represent my client with all of my mind, because that's the ethics I took to represent the man to the fullest. Now, what does this verdict make of the country? Not Samuel Tweah. Samuel Tweah, as far as concerned under the law, is a free man. What happens, what the verdict for this country is tomorrow. And this is the precedent. It means that when the verdict comes out tomorrow, and they found somebody guilty, even if the man spent 2 months or 1 month in the community, he rejoicing, Somebody can just try and file a paper in there and say during that hearing we discover something, and that judge can come and hear it and set that verdict aside. It violates double jeopardy in due process. The Supreme Court of the United States that will cover all of our precedents from issues that exist in Liberia that cannot be, that do not exist, that there is no law on, says when you have disbanded the jury and they go into the community, to bring them back is unconstitutional. It's legally improper and dangerous. That is what the law says.
Can we
infer any political manipulation given what is
Can we infer any political manipulation with the judge given what we heard from the minister?
Well, Samuel Tweah spoke from his own perspective. For me, I'm only a lawyer. The man is a former finance minister. Being the former finance minister, one of the most powerful presidents that has served in government, next to the president in any country. So maybe he spoke for his clear intentions of intelligence, who gave him information, whoever.
Counsel, how prepared is the defense to proceed with this trial?
I want the government to tell the truth.
Counsel, what will be our next action? What will be our next action now?
No, we want Supreme Court. We're taking it up. We're testing the law. Our duty as lawyers is to test the law. We don't put our personals in the case. We're testing the law. So we go into the Supreme Court to see whether the judge has jurisdiction, whether the decision he took, he has. The lawyer representing the jurors will have their own to say. The lawyers representing the defendants who had the verdict will have their own to say, because we have our own to say that the judge has no jurisdiction, and two, that the jury have been disbanded, and because they are disbanded, you calling them back is unconstitutional. It's illegal. Yeah.
So you hear from Councillor Arthur Johnson. So I'm moving to my colleague Mama Jallo. So you keep following. Mama is here. She's here to bring us to speed about what actually unfolded today in the court. So my name is Faso. I'm here behind the camera bringing you this live from the ground of the Supreme Court. All right. Good afternoon, Mama.
Good afternoon.
So bring us to speed about what actually unfolded today at the court.
Oh, well, what happened just now, I think, is something that is not usual. We've not really seen this in our judicial proceedings.
Okay.
So we just had a ruling from the investigation that was conducted for the juror tampering. That, you know, an alarm was raised that the juror has been tampered with, and they just gave a report from that particular investigation, and the court has said that indeed there was a juror tampering, and that all the 15 jurors that sat for the trial should be arrested and detained at the Monrovia Central Prison, and that the case will now go for a new trial, and that all those that communicated with these people while they were in juror court or juror court anyway, they will be investigated too. I mean, so the appropriate authorities will go back and investigate these contacts, and if they are found, whatever is going to be found, they'll go by the procedure and they'll take them to the rightful authorities.
So have did the judge come up with any specific date when the actual the retrial going to commence?
No, he did not. He only talked that there will be a retrial because there is juror tampering.
So meaning there was evidence proving that the juror were tampered with.
Yeah, from the investigation.
From the investigation.
Yes, they even summoned the GSM companies, both Lone Star and Orange.
Okay.
These people provided call logs, and through those call logs, they realized that actually the jurors had telephones with them, and they were communicating outside. So they've been charged with, not charged I would say, but there is juror. So more like disobedience.
Okay.
They know that they shouldn't have done this, but they did it anyway.
Okay.
And
so meaning there's a law that prevents them whenever you are selected as a juror.
Yeah,
you are not allowed to have access to telephone.
Yes.
So
no SIM card, and there were a juror there who had access to telephone.
Okay.
And other jurors were using that telephone to communicate outside.
Okay. So thank you. Before I take a leave of you, what?
I got one more thing to add.
Okay.
I believe Councillor Johnson, you listened to him.
Yeah.
He has accepted to that particular ruling from the court. He
Okay.
said that they are going to take it to the higher court.
Okay.
They're going to challenge that because it's unconstitutional to disband a jury and then later call them back and say, oh, this is happening. So they're going to take it up to the higher court.
All right. Thank you, Marama.
All right, thank you.
So thanks for watching. My name is Fasu. We'll meet again at another point. I was here bringing you update from the ground of the Supreme Court.